Howdy, and welcome to the White Hat Law Show with Warren Nord, where we cover a mix of current events, politics, and the law. Take it away, Warren.
Hi, welcome to White Hat Law. I'm Warren Nord, and we're going to be here talking about Chapter 11 bankruptcy. With me today is Clayton Everett. You may have seen Clayton before when we talked about liquidation, I think it was a few months ago. And so
it's nice to be back on the show again. Thank you for inviting me.
Well, it's my pleasure. So we have Clayton on when we talk bankruptcy because he knows a lot more about bankruptcy than I do. So, but I always should start with this, but I rarely do, so I'm going to do it right just at least one time. This is not legal advice. We're going to talk about legal matters, but we're going to talk about it in a broad way. And it's for the purpose of helping people kind of get a general understanding. But please don't go to a judge somewhere and says, well, Warren and Clayton said that this is not legal advice. You are welcome to come join us at our office, and we'll talk about your situation, and then we can have some legal advice. So, Clayton, what is Chapter 11 bankruptcy?
Chapter 11 bankruptcy is designed for individuals and businesses to readjust their financial situation so that they can extend long-term debt or get rid of some of the debt and preserve the ongoing value of a business.
Well, how does that differ from, say, a Chapter 11 or a Chapter 7 or a Chapter 13?
Well, it's similar to a Chapter 13, and if you can fit into a Chapter 13, that's what you want to do. But there are pretty small debt limits in a Chapter 13 that would prevent most individuals, large individuals with business stuff, from filing a Chapter 13. And business entities are not eligible to file 13s. Now, Chapter 7 is a liquidation, in which case you basically turn over the keys to the trustee, and the trustee liquidates and then sells the assets and distributes them to the creditors.
So a 7 is designed to end the business or to cease. It's a kind of a real endpoint.
Yeah, that's correct. If you're filing a Chapter 7, it's basically going out of business, and you're just shutting it down and then distributing it evenly to your creditors.
Whereas in an 11, we're trying to save the business.
Generally, that's true. Now, you can also sell a business in a Chapter 11, and you can actually control how you might sell assets in a Chapter 11. That would be a Chapter 11 liquidation. But typically, most filers are trying to preserve the business and continue operations. So,
I mean, I've seen Chapter 11s. In fact, I've helped file Chapter 11s where we were hoping to have a salvage and to save the business, but it turned into a salvage because the guy who says he's going to come up with the money to help out here and there doesn't, and so it winds up being a sale to the highest bidder. So it doesn't always work out the way we want. But generally speaking, we're trying to.
And one of the advantages of a 11 is that the debtor will maintain some control over that, or at least has the possibility of control over when to decide to liquidate, if they end up choosing to liquidate later within the process of the Chapter 11.
Right, because in a 7 or a 13, there's a trustee that's appointed that kind of runs the show, whereas in an 11, the person filing or the business is the trustee, acts as the trustee, the debtor in possession, so to speak.
Yeah, and you have some of that also in a Chapter 13, but yeah, that's generally pretty correct.
So, if I'm considering a chapter, I've got a business and I'm in trouble. Mm-hmm. When should I come see you, and what questions are you going to ask me?
Well, you need to come see me pretty much immediately. Once you realize that you're not able to service your ongoing debt, you should visit with a bankruptcy attorney to discuss what kind of
maybe
options.
Even before you get to that, when you realize you're going to have a run rate that says I'm going to be out of money in 3 months, and
Absolutely.
So it's not going to be pretty.
Absolutely. The more time you give an attorney before you need to file, the better you can actually plan on filing. And there's even some stuff that's going on now with pre-packaged bankruptcies if you have cooperative creditors. But the key is to kind of, an ounce of prevention is worth a pound of cure, I think is the saying.
Yeah, I always tell people we're so much cheaper on the front end than the back end. And although it's always on the front end of the bankruptcy, but it's still trying to do something at a sane speed is easier and cheaper than trying to do something. I've got a foreclosure on Tuesday. Can you save me when you come in and see me on Friday?
And obviously, foreclosure, evictions, lawsuits, those are all good reasons to go ahead and visit with a bankruptcy attorney.
Right. Okay. Well, good. Tell me, there was something else that I wanted to bring up. That sometimes people have several stores, and so that one of them is failing, and they need to dump that one off.
Yeah.
But you have several leases. In 11, you can reject contracts, right?
Yeah. One of the big benefits, I think, especially for small businesses, is they may have a contract or two that's really just pulling them down, and Chapter 11 will allow them to either reject or accept the leases that are unexpired. And so that can be a very powerful tool for businesses to shed unwanted contracts, and that also includes, payment contracts and employment contracts as well.
And that, quite often, of course, that helps along a renegotiation of some of those contracts sometimes.
Right.
So that's good. Okay, so what kind of time limits, if I'm going to file a Chapter 11, what would I expect to see as far as a time limit or time process?
So once you file a petition in Chapter 11, that's kind of considered the cleavage date. That's the demarcation of when, the claims in the past stop and need to be handled in the bankruptcy or gotten rid of, and the new claims that will be coming with the ongoing business. And the important early part can be quite hectic and quite busy because you've got an operating business, and you're going to have to file a lot of first day motions. You're going to have to get the attorney's fees approved and attorneys employed in that case. So there's a lot of really short-term upfront stuff you have to do. And then the longer-term process is about 120 days, to file the plan, and then 45 days or so, or after that, to get the plan confirmed.
Yeah, I've always found that a lot of people who have hired a lot of attorneys are surprised to find out that in bankruptcy, the judge has to approve your employment, which I think is the only place in the law where this occurs.
Well, and it's not without reason, Warren. I mean, obviously, you got a distressed debtor. They have limited assets, so there's an interest to preserve the value of the estate, and I think that's why the courts, that's why it's in the code that the fees need to be reasonable and approved.
I think too. Also, I tell people that we are kept as horses in a stable, and so you go to the stable master and you say, "Well, I've got to pull the equivalent of some Wells Fargo wagon full of gold. You're going to need a serious 8-team group of horses to pull that, so you want an organization that has the background to do that. Whereas if I'm just going to go fast and smooth through this valley, I can take one little horse and I can have a smaller organization do it." And so they want to make sure that if I had, for example, tried to file the Rangers, a few years ago, Judge Lynn might have said, "I don't know, Warren, do you have the 15-person team to do that?" And I would have said no. But
I've never thought of it as a gatekeeper to, making sure you have competent counsel. And is that what you're
I
suggesting?
think that certainly that's part of it.
I've not seen that, but that's an interesting point.
Yeah, at least that's the way I always felt about it. maybe that's just me, but so far nobody has said that I couldn't do it.
Yeah.
So far I'll take it that way. And then the other thing that I like about Chapter 11 is that you can do, it's very creative. In a 13 or a 7, they're really straightforward rules. It's kind of like doing math. You're just following the rules. Then you get to geometry. Suddenly, you don't do everything the same way. You can negotiate things that are easier to do.
Yeah, I would agree with that. 11, because in a 13, the debtor maintains a lot of control. You give up some of that control in an 11, but in exchange, you get the chance to be pretty much as creative as you can, and as creative as the creditors will accept. You can put in a plan.
Yeah. So, well, we're going to take a break for just a second. We're going to come back. We're going to talk about a couple of typical situations where we've seen Chapter 11 be successful, and a couple when they haven't been. And we'll talk about some kind of frequently asked questions. So we'll be right back.
Whoa, hang on to your hat, folks. More with Warren Nord when we get back. Y'all are back here listening to the White Hat Law Show. Warren, who do we have up next?
Welcome back. Thought we'd talk about a couple of examples of where bankruptcy, Chapter 11 bankruptcy was employed, and some examples when they may have not done as well or did pretty well. My favorite example was a client I had a couple of years ago that had 6 triplexes in an oil boom town. And so when the oil went away and the boom went away, he found himself with several triplexes that were all underwater by about $100,000 each. So he had renters in some and not renters in others, and the value of the foreclosure value of the triplexes around them were being sold for about $50,000, $45,000, but they were all sold originally at about $150,000. And so when he came to me, he said, "Well, what am I going to do here?" And we were looking at a 7, but the fortunate thing in this case was that all of the lenders, we had 6 triplexes, and one bank had 3 of those notes, and one bank had 2 of those notes, and a third bank had 1 of those notes. But they could all see the foreclosure value was between $40,000 and $50,000. And so he said, if you will renegotiate the principal of each one of these triplexes to $60,000, they're still losing $90,000. But they have an owner with renters and somebody who's paying them for the other 60, and they all agreed to do it. And it was a great deal for everybody concerned, so as good as it could be under the circumstances. And so we were pretty excited about that and making that happen, and that completed on time. And so everybody there did better than the people who just let it foreclose. And so everybody's better off. Another example that we had that wasn't so good, we had a church, and they really just wanted a few months to sell their big church property. And that was going to be a sale in a Chapter 11. And it went on and on and on. And finally everybody said, we'd like our money or the property, and we had to give it up. That one we actually dismissed. We didn't take it into chapter. We did not convert to a 7. We just dismissed it. And
What was the thought behind that? Why not just convert to a 7?
Because he wanted the ownership group wanted to see if they could have additional time to find a buyer before the actual eviction occurred. And so it was just buying a few more minutes, and they didn't have to pay me to do a conversion and to do all that work. And so,
Is the property still being operated as a church?
It's either been knocked down or it's still being operated as a church. It's a big building. Some of these church buildings are church buildings, and that's about it. So. I was sad to see that one go that way, but that's what happens sometimes, right? You don't know what's going to happen.
Often you don't. I've had a similar one that was operating out of in East Fort Worth, a church in basically a converted Kroger store. Phenomenal amount of money that's run through a church organization, but it can be really difficult to get those to completion.
Well, I've always. The engineer in me cries when I see a big building like that that's full only about 2 hours a week. So you got to air condition it. You got to do lots of things, and so it can be difficult unless you're using that building right. One other option, one other story that I like to tell is a screen printer that's here in town. The owner was a very generous soul, and he effectively was just too generous. Generous to a fault, one might say, about giving people good breaks. And so it was not being run profitably. And so we had a person that came in and said, I will buy all the assets and I will take all the debt, and I'm not changing it. So it wasn't a sale. It was just an infusion of new money and new ownership of the LLC in a way that worked out really well for everybody. And so and today that organization is operating just the way it should be. But again, it's a situation where some serious changes had to be made. I always use the word recalibration to say that we have some expenses and some duties that just are not sustainable. So what you hope to do is you have to see these things coming before they actually crater the business, because you have to pay attorneys to do these things, and you have to have some a little bit of leeway, a little bit of money in the bank in order for these things to happen. You mentioned first day motions a minute ago, and some people don't know what that means. Tell us about first day motions.
Well, it's just I don't think it's an official term in the bankruptcy code, but it's in the early part of a business bankruptcy. There are things that need to be paid. Oftentimes that's payroll. You need to use cash collateral. That might be an issue. And there's some other ongoing things.
Now, what's cash collateral?
Cash collateral is any sort of revenue that is generated by the business, or cash-like assets generated by the business that a creditor may have a lien against. And so in a Chapter 11, you can't use that cash collateral without permission of the bankruptcy court and without notice to those creditors.
So as an example, if I've got a restaurant or a screen printer and they're being paid for the t-shirts that people are, or the food every day, money comes in. The day you file Chapter 11, the cash comes in that day, cannot be used to pay for the salaries the day after, right? Unless you have permission.
Without permission of the court, assuming that someone has a lien against it. Yeah.
Right.
Usually that's the case. In most businesses.
That's why they're filing bankruptcy. Is there somebody who's got a note somewhere that wants to get paid?
That's correct.
And so if you borrow money for a business, usually there's a lien, the note holder, the banker, the Small Business Administration's bank that's working with you will have a lien on the equipment, the yogurt making machine,
accounts receivable,
all the money that's due. Now, if you're dealing with a restaurant, you don't have a lot of accounts receivable because people pay for their food as they're going on. If you're a t-shirt shop, you've got you're selling to schools, people like this, and so you'll have 30-day notes, and so you might have a accounts receivable that says you're owed $50,000 or $60,000. The bank owns all of that. In theory. And so you have to have these first day motions, and the reason we're calling them first day motions is because you really need this permission here pretty quick, and so you file them very quickly after the bankruptcy is filed.
And you need permission to pay any sort of payroll from prior to filing.
Right. Yeah, so the utilities, payroll.
And that's usually something really important if you want to keep your employees happy so that they can not get scared away by the filing of the bankruptcy.
Right. So these are important matters and this is why the prepackaged Chapter 11 is a big deal, because it allows you to cooperate with these people. Quite often the bank has already agreed, yes, it's no problem, we'll let you use the cash.
And one of the keys to the prepackaged bankruptcy is really getting to your attorney with enough time to prepare the prepackage.
Right, make deals with people, right? Because the IRS has to say, if they've got an IRS lien, which is not uncommon, they have to say it's okay for you to use this money. So everybody has to be on board. So it makes it for a much easier, much less expensive bankruptcy. So again, it's one of those things that if you deal with people up front, you have plenty of time, then you can do that. And quite often, if you deal with somebody early enough, you can actually avoid the bankruptcy completely. I've got a client that's in town, and they owe a ton of money, but it's mostly to one organization. So we prepared all the documents, and we sent it to them and said, look, you're really the only driver of this bankruptcy. If we could work something out, then we don't need to file it. And they said, we don't want to hire a bankruptcy attorney to do this. We'll work something out. And so that's always nice whenever you can actually make it work without having to file the bankruptcy. Let's talk about it. Let's take a break real quick, and then we'll come back and we'll talk about creditors and how a creditor looks at a Chapter 11 bankruptcy. We'll be right back.
Whoa, hang on to your hat, folks. More with Warren Nord when we get back. Y'all are back here listening to the White Hat Law Show. Warren, who do we have up next?
Welcome back. Okay, if you're a creditor and you start to smell, I'm getting late pay suddenly. It's not going the way I thought it was. And suddenly, or either you hear through the grapevine that somebody's talking to a bankruptcy attorney, or that there's been a filing of a bankruptcy for this company, and they owe you money. What do you do? And they call you, Clayton, what do they do?
Well, you see what powers you have under any sort of contractual obligations you may have with the party. If you can, maybe start asking for COD, cash on delivery, if the contract allows you. Other than that, you have to kind of wait and see what's going to happen.
I always tell people, if you don't spend that money
Yeah.
that they pay you, because there's clawback thing that goes on in bankruptcy sometimes, and you have to fight over the money that you've already been paid. This is a horrible thing that happens to people.
It does seem horrible. Of course, in the bigger context, if you're a creditor that's not getting paid, then that's good news for you, because any sort of payment right before the filing of the bankruptcy might go back into the state and perhaps get distributed out to creditors in an even fashion.
Yeah, let's talk about that for a minute. So if you're working with somebody and you're doing work and you get these huge payments on the eve of their bankruptcy, and then they file, the rules are suggest that generally like creditors get paid in a like manner, right?
That's
so and I'll just use clothing. The guy who's selling you the shirts, and you sell them, you owe everybody $100,000, but you pay your brother owns the shirt company, so he gets paid this big bunch of money, so he's okay. And then the bankruptcy is filed. Well, there's a situation there where it's not fair, right? And so the bankruptcy process says, no, you've got to take that money back, and you've got to divvy it out amongst all the creditors. Called a clawback. And there are other rules about making sure that inventory that is received on the eve of bankruptcy either gets returned or paid for, versus other people that just, I think the technical word is hosed. Maybe that's not the technical term.
I don't think that's in the bankruptcy code.
Maybe not, but it's right there close. It's on maybe the Apocrypha. I'm not sure. So that's a major issue. But generally speaking, it's creditors are more involved in a Chapter 11 bankruptcy.
That's correct. In a Chapter 11 bankruptcy, creditors get to vote on the plan if they're impaired, and they will have a lot more opportunity to participate in how the plan treatments are done.
Impaired. Why are these people disabled? What does that mean?
Impaired in the bankruptcy context means that their claim is getting adjusted somehow, whether that's going to be diminished in the value that's being paid out or the term it's being paid.
So if I owe $1,000 a month for 5 years, I might go to $800 per month for a longer period of time.
Yeah.
Any kind of change to the terms that's detrimental, it means it's impaired, right?
That's correct.
Okay. And so all those people get to vote on whether or not the plan will be accepted, right?
That's correct.
Now, can they say, we think this person should go to jail instead of paying us, or what else do they get to do that might be interesting?
Well, for the most part, they don't get to send the debtor to jail unless there's been some sort of fraud committed. But they do get to file a claim and otherwise litigate any sort of claims they may have against the debtor.
They can object to the plan. Besides voting against it, they can also object to the plan and say the plan doesn't do what it's supposed to do.
Yeah.
Right.
If they feel they're not getting treated fairly, for instance, they can point that out to the court, and that would be taken up in the confirmation.
And we don't want to get too technical about it, but generally speaking, what we're trying to do in a Chapter 11 is be better than a liquidation, right? It's be better than everybody just taking their losses and going home. But that doesn't mean that the debtor can treat some people really well while others don't get treated well. Although it's always better to be secured than unsecured, right? Some people understand, I say sometimes, we all use words that some people understand, some people don't. Could you explain what secured means to you?
A secured creditor means that they have a monetary claim against the debtor, and they have a right to collateral and satisfaction of that claim. And that's essentially what secured means. And the value of how secured they are, whether they're like undersecured or oversecured, just has to do with the value of the collateral versus the value of the claim.
So if I've got a strip mall that's worth $2 million and I only owe $400,000 on it, I'm oversecured, right? Because I can not pay for quite a while, and the bank knows that it can always get its money.
Right.
Whereas if it's worth $1 million and we discovered a foundation problem and it's going to cost 1.2 just to bring it back up to speed, well, I'm clearly undersecured. So these things matter because it's better to be secured than not secured. Now, sometimes in a Chapter 11, and this is still true of all bankruptcies, we can object to claims, right?
Yeah, you can object to a claim just as you would be able to defend a lawsuit to enforce that claim. So you'd have similar, the similar kind of defenses you would have in outside of bankruptcy.
Well, and let's talk about the impact of a Chapter 11 on lawsuits. What happens if I file bankruptcy and I've got a lawsuit where I'm going to get a default judgment the next day for $1 million? Does that hold water, or what happens?
Well, the biggest benefit, I would say, of filing any kind of a bankruptcy is the imposition of the automatic stay, which stays most types of litigation and any kind of collection actions against the debtor or the debtor's property.
So, if I file a bankruptcy and it stays all litigation, even if they don't know about it, right? I mean, because I've seen people will say, well, we foreclosed on your house this morning. In fact, I had this problem with it. It was in the afternoon. He went to chain a certain store in town, put chains across it, and I got the call, and I had to call the attorney and say, hey, we filed bankruptcy this morning about 9:30. And he said, it'd be nice to call me. And I said, I tried to call you, but it's too late. He was out doing something, and so he had to go let the chains out because we had filed the bankruptcy before the chains had been put across, and it would have been very different if they'd put the locks on the day before. It would have been very different.
Yeah, timing definitely matters, and never any more than in a situation with the automatic stay.
There's no doubt. Now, of course, and sometimes this comes into play in unusual ways. I mean, in divorces, for example. Divorce is just a lawsuit, right? Mm-hmm. So what happens when you file divorce?
So it'll stay that typically anytime a judge that's not a bankruptcy judge sees a petition for bankruptcy, they don't want to touch it. Now, that's usually the case. And in all cases, the action should be stayed.
Right.
Now, in a divorce context, you can go ask permission from the court to lift the stay to go ahead and finalize the divorce.
And usually,
but you do have to ask for permission from the court.
And usually, the other side, everybody in the family world knows that has to happen, and they're usually everybody's fairly reasonable about this. But occasionally, you get strange things, and so I just wanted to mention that because we have some suburbs where you have a lot of people that are double income executives, and whenever there's nothing more stressful to a marriage than financial stress, and so sometimes you'll wind up getting a person who can't qualify for a 13, they'll file an 11, and they wind up interfering with the divorce, where the divorce is interfering. You just have these problems, and so you have to work through this. And most attorneys know that this has to be worked through. What are we missing, Clayton?
We talked about the automatic stay. We talked about executive contract.
Involuntary.
Oh.
Involuntary. So tell me about involuntary bankruptcies.
One unique thing about the bankruptcy code is that it's not only the debtor who can file for bankruptcy. Creditors can force insolvent debtors into a bankruptcy proceeding.
I've always found that to be fascinating, and I've always wanted to do that to a deserving debtor. It's not something I would wish on anybody I like, but it's three creditors. Mm-hmm. That have a certain amount. There are rules to it, right? And it's not for the faint of heart, because if you do it and you don't have your act together, then you can wind up paying fees. But the key thing to understand is that if you are in a situation where everybody knows you're in trouble, you need to be on top of this, because one of your creditors can force you into the bankruptcy, and that is far worse than walking into our office and saying, help me do this, so that I don't get forced into it. So I think that covers it. Clayton, Everett, thank you very much for coming in today and helping us through this. If you find yourself in a situation where you've got a business that needs some recalibration, maybe to dump off a bad branch or bad store, or just to fix one major debt, or to get just things a little bit better off than they were, And it's salvageable. It has to be salvageable. We can't do miracles. We can do magic, but not miracles. And so give us a call at NORAD Law. And thank you for tuning in, White Hat Law. We'll see you next time.
Well, that's a wrap, folks, and we want to thank you for listening to the White Hat Law Show here with Warren Norrid. To find out more about Warren, check him out at noradlaw.com. See you next time.